Well, here I think I need to make a distinction between the classic Chapter 11 and the subchapter 5 Chapter 11. The classic Chapter 11 is a bit more complicated, and as a result, it's much more flexible. The creditors get to vote in that classic Chapter 11, and you have to get the creditors on board. If they're not on board, you can't get that plan confirmed. Now, there's a more precise way to put it. The creditors are broken up into classes according to the types of claims they have. They do vote individually, but their votes are tallied within the class. And if a class votes in favor of confirmation, then the plan has the potential for being confirmed. Ideally, you want all the classes voting in favor of the plan, in which case you have what's called a consensual plan. And then the judge will confirm the plan, end of discussion. You can get a plan confirmed even if there are some non-consenting classes, as long as you have at least one consenting class. The problem there is it triggers some absolute priority rule. With the absolute priority rule, all of the assets are lost by the stakeholders, the owners of the company. They go into the estate, and if they want to get them back, they have to buy them back from the estate. But if it's a consensual plan, then the stakeholders, the owners, don't lose anything. So that absolute priority rule is best understood if you have in your mind this image of one of the fountains I'm sure you've seen, where there's a succession of bowls, each bowl larger than the one above it. And at the top, there's a water source. And the water source fills up the top bowl first, then the water spills out to the next bowl, and then that one fills up and the water spills out to the next bowl, and so on. Think of the bowls as being priority classes. So the top class has to be paid in full. It has to be filled with water before the next class gets anything. The bottom bowl, that is the stakeholders, the owners of the company. And so if the plan is consensual, everybody votes in favor of the plan, or every class votes in favor of the plan, it can be confirmed and we're happy. If one class, at least one class, votes in favor of confirmation, but there are some non-consenting classes, then unless everybody gets paid in full, all the bowls get filled with water and the bottom bowl gets filled with water, the bottom bowl gets nothing. Those are the stakeholders. So maybe the best way to think of it in terms of the bankruptcy estate is, prior to filing the bankruptcy, the debtor has assets and the debtor has debts. When the debtor files the bankruptcy petition, that act creates a bankruptcy estate. What goes into the estate is everything the debtor owns or has an interest in, and then the debts become claims against that estate. And the bottom claim, if you want to think of it as a claim, that's the stakeholders. So that absolute priority rule is very important in crafting a plan for the stakeholders, because you really want to get a consensual plan if it's a classic Chapter 11. Now, I mentioned the subchapter 5, Chapter 11. A few years ago, Congress enacted and the President signed into law an amendment to Chapter 11, which added a subchapter, subchapter 5. And the idea was to streamline the bankruptcy process for small businesses. And there is a bit of a technical definition of what we mean by a small business. The gist of it is there can't be more than a certain amount of debt. Now, that's in a little bit of a state of flux right now because it had been increased with COVID. Now it's coming back down. So I don't want to state a number and then you're watching this video some months later and somehow the numbers have changed. In any event, the total debt can't exceed a certain number, and the debts must have been at least 50% accumulated as business debts. So if it's a small business, the small business can do a subchapter 5, Chapter 11. So in a subchapter 5, we still propound a plan of reorganization as we do in a classic Chapter 11. The creditors still get broken up into priority classes as in a classic Chapter 11. the creditors get to vote and we tally the votes. However, in a subchapter 5, we can get the plan confirmed even if it's completely non-consensual. No creditors at all vote in favor of the plan. Although I will say the judge is going to look very carefully at whether or not this plan satisfies the basic requirements that are listed in Section 1129 of the Bankruptcy Code to see, is this plan something that is fair and reasonable and equitable. In any event, you can get the plan confirmed even if it's completely non-consensual and there is no absolute priority rule. So in that situation, the stakeholders do not lose their stake in the company. Remember in that classic Chapter 11, if we have that absolute priority rule triggered because we're trying to get the plan confirmed and we have some non-consenting classes, and we do have some consenting classes, then all of those assets that went into the bankruptcy estate remain in the estate and can be liquidated for the benefit of creditors, and the stakeholders only get to keep those assets if they buy them back from the estate. But in that subchapter 5, there is no absolute priority rule, so the stakeholders don't lose their interest in the company. As a result, if it looks like there's going to be a bit of a contentious case, if possible, we like to put the debtor into a subchapter 5, Chapter 11. That way, the principals don't lose their interest in the company. Now, all of what I've just described, of course, is within the context of a business Chapter 11, whether it's classical or subchapter 5. It turns out that non-business debtors, individuals and legally married couples, can still file under Chapter 11. Generally, we don't recommend it unless there's a compelling reason. Generally, those reasons, well, a couple of reasons. The debtor has too much income to qualify for Chapter 7. There is a way that that statement can be made precise. And the debtor's debts exceed the debt ceiling for Chapter 13, which is a very light version. We could think of it conceptually as a light version of Chapter 11. Chapter 13 not being available to businesses. So if the debtor can't do a Chapter 7 and can't do a Chapter 13, that's when we put an individual or a legally married couple into a Chapter 11. Part of the reason we don't like to do that is because it's so very complicated. It's by far the most complicated chapter in the Bankruptcy Code. In any event, there still is the absolute priority rule in the classic Chapter 11 for individuals and legally married couples, and that can be a real problem because, for example, one of those assets that goes into the bankruptcy estate is the debtor's principal residence. And of course, people don't want to lose their principal residence. So if possible, we like to put the debtor or the couple into a subchapter 5. There still is this issue of, can they be classified as a small business? So they do have to have business debts, and more than 50% of those business debts have to be, or of their total debts have to be business debts. And there's also the debt ceiling for qualifying for subchapter 5. But in that situation, if possible, we like to put the debtors into that subchapter 5, even individual debtors, because there is no absolute priority rule. And again, we can get a non-consensual plan confirmed. If we're in the classic Chapter 11 and the debtors are individuals, individual or legally married couple, then we still have to contend with getting the creditors on board. Will they vote in favor of confirmation? And if we want to get the plan confirmed and we have a plan that not all the classes vote in favor of confirmation, then we trigger the absolute priority rule, and then you could have the awkward situation where the debtor has to buy his or her home from the bankruptcy estate. One softening of the blow on that is anything that's exempt. The concept of exemption doesn't exist for businesses, but for individuals, the principle of all the assets go into the bankruptcy estate and the debts become claims against that estate is still true. But unlike the business, in an individual case, we can take assets out of the bankruptcy estate using exemptions. And there are two exemption tables we use in California. one for homeowners with equity, the other for everybody else. So it is certainly quite possible that in a personal classic Chapter 11, the debtor could still keep the house if, for example, there is equity that is below the exemption threshold. So it isn't necessarily as dire as I just painted it out. I was thinking more in terms of broad brushstrokes rather than getting into the weeds. So the long and short of it is we think very long and hard when crafting a Chapter 11 plan about making sure that the stakeholders, the owners, get to retain their interest if at all possible.